Professor Menhout, thank you for your invitation and for the floor, and indeed for the following time remainder to the lunch break, and for which I am very much aware of my responsibility. I will be talking to you about the limits to using AI to evaluate credit risk according to the AI Act. And I shall structure my presentation according to the following. First, in some introductory remarks, I will present the main provisions of the AI Act that justify the inclusion of credit evaluations in this act of legislation. I will then delve into the elements of the AI Act on credit scoring and creditworthiness, but also following this part, I will talk about the obvious divide in this act between the natural person and the legal person statuses, the consequences of high-risk AI classification, which have already been mentioned, and I will attempt not to repeat what has already been said during this conference. And finally, I will present some practical hurdles to compliance with the regulation, as well as some of my conclusions. Now, first of all, and before we would begin, I would like to address what sometimes in scientific discourse is called the elephant in the room. That is the nature of the AI Act and the method of regulation. The AI Act follows the same method of regulation that was followed by the GDPR and other European instruments, in that it creates a regulatory environment that is quite complex. Some have called it a Ruby Goldberg machine, that is a machine with many moving parts, too many moving parts in fact, for the intended purpose. Others have criticized the structure and so on. The main issue regarding this regulatory solution that the European Union has adopted is that it intends, for probably the first time in practical application, to resolve problems that would be posed in the future. Law is usually reactive, and so problems are usually resolved when they occur and as they occur. However, the AI Act is trying to predict the rampant development of technology and this direction of development, and where to stop development from turning into problems. And this method of regulation entails problems of its own because it tries to be predictive in ways that may not well align with practical problems. And we will see in the problem of establishing credit scoring and creditworthiness that already the AI Act has missed one of the major issues that practice has thrown at, or is throwing at participants in credit relationships. Well, first of all, about the regulation and where the rules lie in this regulation. The AI Act, as we know, has an entry into force mechanism that is quite complex. The regulation is in this act. It will be applicable mostly on credit contracts from the 2nd of August 2026. Now, for the scope of the regulation, the scope is evidently extraterritorial. So Article 2, Paragraph 1 provides for the application of the AI Act for all those providers who place on the market or put into service AI systems, or place them on the market as general purpose AI systems in the European Union. So extraterritorial application is a given, which means that we should apply the AI Act, including its provisions on establishing creditworthiness and credit scores, including to providers that are outside the geographic area of the European Union. And as we have seen in Article 6, the AI Act provides that high-risk AI should be regulated more stringently, and establishes what categories of AI are high risk. Now, in recital 52, the AI Act mentions that in addition, AI systems used to evaluate the credit score or creditworthiness of natural persons should be classified as high-risk AI systems, since they determine those persons' access to financial resources or essential services such as housing, electricity, and telecommunication services. AI systems, says the law or act, used for those purposes may lead to discrimination between persons or groups, and may perpetuate historic patterns of discrimination, such as those listed. AI systems provided for by union law for the purpose of detecting fraud are evidently exempted. Now, this recital gives us an insight into the mentality of the European legislator, in the meaning that it wishes to regulate credit scoring and creditworthiness when realized through methods using AI, especially for the purposes of avoiding discrimination and infringement of fundamental rights. Therefore, the focus of this regulation will be on natural persons, as these persons are those specifically considered to be endowed with these fundamental rights that the European legislator does want to protect. Now, in addition, the European legislator at recital 158 gives us the following. As regards AI systems provided or used by regulated and supervised financial institutions, unless member states decide to designate another authority to fulfill these market surveillance tasks, the market surveillance will be conducted as it is conducted for other such institutions. And therefore, a regulatory regime, basically copy-pasted from financial institutions, is implemented, including for the use of AI on credit scoring and creditworthiness. The regulation at Annex 3, this famous annex that contains the list of high-risk AI implementations, states that AI systems intended to be used to evaluate the creditworthiness of natural persons or establish their credit score, with the exception of AI systems used for the purpose of detecting financial fraud, will be considered as being high-risk AI. It is worth dissecting this rule, firstly because the text refers to AI systems intended for this use. This means that AI systems that can be used in this way but are not being used in this fashion will not be considered as being high risk so long as this intention does not exist, which is, of course, problematic. Especially for practicing lawyers, we should mention here one issue. How do we prove intent? How do we demonstrate that a system was intended to be used for creditworthiness? Do we demonstrate it from the effect it was used that way, or do we actually tend to demonstrate that there was an intention for this type of use? The major issue of the regulation, which I have mentioned already, is the divide between natural persons and legal persons. And here I would very much like to refer to Professor Menhardt's earlier presentation in what regards the necessity to protect the weaker party. European Union law generally considers that natural persons as consumers are the weaker party in relationships between them and between service providers of various kinds. However, in the field of AI, we have certain specific elements. One of these specific elements is that this field is not dominated by the European Union. The European Union has chosen the solution very familiar to fans of Formula One, where if we're not winning the race, we're going to set the rules. And therefore, the European Union has chosen to legislate AI while not dominating the field. And this brings us to the next problem. It may be possible for legal persons within the European Union to suffer the effects of AI, creditworthiness, and credit score establishments under the AI Act, while these actions of establishing creditworthiness and credit scores come from third states, specifically from the United States, which is currently dominating the race to achieving AI supremacy. So therefore, we have an area uncovered by the AI Act, or more specifically, not covered by the AI Act, where natural persons are protected to some degree, whereas legal persons are protected to no degree at all. The problem is more complicated than it seems. When we compare the provisions of Recital 52, for example, with the provisions of the European Convention on Human Rights. The recital mentions specifically the intent to avoid discrimination. Now, this would lead us to Article 14 of the European Convention, which prohibits discrimination based on most grounds if perpetrated in such a way that it is materially infringing on a person's rights as a subject to the Convention. Now, in the view of the EU, such risks exist for natural persons. The problem is that this view does not chime very well with the view of the European Court of Human Rights. There was a case a few years ago, Granus Organicus Nationalis versus Germany, where the European Court of Human Rights actually applied the reasonability and proportionality test to a regulation which differentiated between legal persons and between natural persons. This was a case about access to legal aid for legal persons under German procedural law, and where the court did establish that there was no discrimination, but it did verify the reasonable and proportional character of the differentiation of legal persons and natural persons when seeking legal aid, which means that in the very field of non-discrimination, which the EU envisaged as being protected by the AI Act, an act of possibly implicit discrimination between legal and natural persons by the EU legislator itself may have taken place. So companies may one day argue that they are not included in the regulation, and this is discriminatory towards them because it's disproportional, especially when a small or medium enterprise, say from the Czech Republic or from Germany, deals with a giant company from the United States, which is a bank, which would afford it or award it a loan. Also, a problem of legislative technique here is implied by the regulation of fraud detection. Now, fraud detection is not considered to be high-risk AI, either when applied to natural persons or to legal persons. However, I would put to you this question: what is the difference between fraud detection and establishing creditworthiness when done in practice? Do we detect fraud with methods that are different to detecting creditworthiness, or do we use the same methods? Or do we say that fraudsters, while not caught, should be considered creditworthy and that we should not use fraud detection on them before there is some sign of misconduct? This is a problem of legislative technique specific to non-delineation of different concepts which have these gray zones between their meanings. What is the result of high-risk AI classification? Now, this has already been attended as a problem during this conference, so in order to avoid repeating what has already been said, I would just underline that the result is a higher category of compliance measures. AI systems, especially those implying profiling, and when it comes to creditworthiness and credit scoring, these will imply profiling, will be considered high risk. As these high-risk systems are used, they will have to comply with Article 6.2 and with the requirements that follow in the following subsections. Now, the derogations offered here are worth a mention because usually establishment of creditworthiness or credit scoring will pose some risk to fundamental rights by the persons who are subject to AI verification for establishing these traits. Again, high-risk AI classification implies onerous efforts from the developer and the deployer of AI systems, as well as continued effort during the operation of this system in the form of risk management, risk assessment, documentation, logging, and so on, just to make sure that the system complies with the AI Act, which means that such systems, high-risk AI systems, including in the credit industry, will be restricted probably to the bigger actors of the industry, those who are able to comply with the rules, the onerous rules that are set forth by the high-risk AI classification. What are the practical hurdles to compliance with the regulation? I would mention, first of all, two of them. Opacity of AI models, which we know is the black box problem, and algorithmic bias. What is algorithmic bias? Algorithmic bias is a twofold bias. On the one hand, algorithmic bias occurs when the teaching of the AI model, the so-called initial information blocks that are used to teach the AI model, are somehow quote-unquote infected by bias. And this took place, for example, in a very famous case involving the Apple cards. This was a JP Morgan-related case in which the creditworthiness of credit applicants was impacted by their gender because the creditworthiness establishing software in 2009 misattributed certain traits of income and started to utilize these traits as a predictor for creditworthiness. And now algorithmic bias may also occur in another form. Respectively, algorithmic bias may also occur in situations where the data source is quote-unquote clean, it is not biased. However, the weights attributed to this data source during teaching of the AI model are themselves somehow affected by bias. And this is very hard to predict because we can't detect it from the data source, we can detect it only from AI behavior. Now, these are the two major problems or practical hurdles in compliance with the regulation. However, we should also not, excuse me, I turn this off. Oh, sorry, it seems that the end is missing. No problem. Since this is the advantage of knowing it by heart. Other applications or other problems with practical applications include long supply chains. The United States, the dominant power in AI, will usually be the developer of AI models that will be implemented in the territory of the European Union. Now, we talk about the obligations of the developer and we talk about the obligations of the deployer without knowing how long the supply chain is. We may have several developers, several deployers. We may have persons modifying the AI or using their own intellectual property or trademarks on it so that the sphere of liable persons will be increased. It may increase beyond the level at which any compliance authority will be able to check for compliance or lack of compliance by these actors. Also, we know that the AI liability directive is dead in the water. So the AI liability directive, which would have imposed some evidentiary rules on AI liability, is off the legislative schedule of the European Union, and therefore the national evidentiary rules will have to be used for AI compliance whenever applying the provisions of the AI Act on establishing creditworthiness and credit scores. And finally, there is a major lacuna in the text which should be addressed because it will appear in practice. In the United States, during COVID and mostly after COVID, AI has been trialed for a new type of use which consists of dynamic pricing or dynamic price setting. Dynamic pricing works this way. The AI looks at the purchasing history of a person and then determines what price that person should and is capable of paying for a certain product. Which means that if the AI detects that I need some product because I looked at it 12 times on the internet and determines that I can pay a bit more for it than the price that was set for the product will be priced to my ability to pay for it. This means that this type of dynamic price setting, which is already in use in the United States, is a risk in credit contracts and in credit worthiness and credit score assessments. Why? Because credit score assessments in the meaning of the AI Act and credit worthiness establishment do not refer to price. Creditworthiness and credit scores do influence the interest that is being paid, and they do influence the guarantees that are being given, the sureties, the mortgages, and so on, and they do influence commissions. But the setting of the interest may be established through dynamic means, through AI, that some may argue, and I'm certain some will argue, are beyond the scope of the AI Act as it stands. And therefore, in the establishment of creditworthiness and in the establishment of credit scores, we should also include, either by case law or by legal text, and the latter would be preferable, dynamic pricing against those seeking credit. As final conclusions, one, the AI Act is complex and very hard to enforce. Two, there is no legal precedent, quote unquote, for situations that the AI Act envisages. There is no case law. So we have to wait until the 2nd of August this year and beyond before we get a case law that is capable of evaluating the meaning, the notions, and the practical application of the AI Act. And this will take some time to develop. And finally, the AI Act, through legislative intervention, must be adopted to the new realities that will be presented by AI applications that today are not yet envisaged. Thank you very much for your attention.